Mr. Patrick Tay.
Mr. Speaker, I rise in support of the Criminal Justice Reform Bill. I'm supportive of the proposed revamp of the criminal procedural rules. It is laudable that efforts are undertaken to move our criminal justice system toward a more progressive and balanced one. I have some queries which I'd like to raise in relation to some of the changes proposed under the bill. A. Video recorded statements. The move to allow video recorded statements hits the long-standing calls from the legal fraternity and fellow colleagues for the use of video recording by law enforcement officers when taking statements from accused persons and witnesses. The use of video recorded statements aim to better safeguard the rights of the accused persons in the process of taking their statements, go some way towards protecting the officers who are taking the statements against baseless accusations that they had coerced or threatened the witness, and help to reduce the court time spent on unmeritorious challenges as to the voluntariness of the statements given in the police interviews. Video recorded statements can also help to reduce the trauma faced by vulnerable victims of crimes in having to recount their ordeal repeatedly through the investigation process by using the video recorded statements as their oral evidence in chief in court. With the introduction of this new mode of taking of statements, how are our police officers being equipped to take video recorded statements? What training is in place to prepare our police officers and other support persons involved in the interview process, such as forensic specialists and interpreters, for this new mode of taking statements? Will a set of guidelines or practice directions be put together to assist police officers in achieving the intended outcomes of video recorded statements? In putting this set of guidelines together, reference can be made to other jurisdictions' experience in the taking of video recorded statements. In 2016, the Australian Royal Commission into Institutional Responses to Child Sexual Abuse conducted an evaluation of alternative measures used in eliciting evidence from complainants of child sexual abuse, such as through pre-recorded police interviews. It was found that technological problems associated with the use of pre-recorded interviews could impact the trial, delay proceedings, extend trial times, and at times cause distress to complainants. These technological problems include low audio clarity and image clarity, and the failure to capture images of the complainant that allowed for an adequate assessment of demeanor, such as by omitting an image of more than just the complainant's face, or by placing the camera at such great distance from the complainant that facial expressions were not adequately displayed. We can then take reference from these findings and implement measures to ensure such technological issues are mitigated or, where possible, overcome. The Australian Royal Commission also found that one of the concerns among the legal practitioners who were interviewed in the study was the quality of police interviews, which were described as suggestive at times, cluttered with irrelevant details and prone to omitting important evidential details. It was recommended that there was a need to adopt better guidance and address issues in skills development and quality assurance to improve police interview practices. In the same vein, we can do more to prepare our officers to enhance the quality of police interviews. I would also like to seek clarification on the experience of police officers who take statements which can be used as evidence. For example, under the Criminal Procedure Code, statements taken pursuant to Section 258, subsection 1 of the CPC shall be used in evidence if it is made to a police officer below the rank of sergeant. This has been the rule for some time, where in the past sergeants were less likely to be fresh hires and would have had accumulated more experience in the police force before rising to the rank of sergeant. Today, most of the new hires enter the force as sergeants or at a higher rank. Would it be timely to review this rule to ensure that the officers who are taking statements possess adequate experience in the taking of statements for use as evidence? B. Safeguards to ensure security of video recorded statements. The Ministry has also shared that copies of the video recorded statements will not be made available to the defense due to the risk of the recordings being posted online or sold on the black market. What safeguards are being put in place to ensure that the security of these video recorded statements is not compromised, such as through hacking or illicit recording of the video recorded statements? C. Use of screens in courtroom. The bill allows vulnerable witnesses to use a screen in court while giving evidence on the stand to prevent him from being seen by the accused. Once again, we can take a lead from other jurisdictions' experience in the use of screens in the courtroom. The Australian Royal Commission in their 2016 study gathered feedback on the use of screens in the courtroom and found that some defense counsel and judges were of the view that the use of screens was unfair to the accused, as he was not able to see the witness who was giving evidence against him. Some stakeholders also found the use of screens to be ineffective in reducing the witness's stress, as the witness was still aware of the proximity of the accused, and in some instances, the accused could still be seen by the witness when the accused moved. Also, due to the layout of the courtroom, the witness would also often still be seen by the accused, as he had to walk past the accused to get to the witness box. Some courtrooms also did not utilize well-designed and purpose-built screens. As a result, the use of a screen was viewed as a negative experience for the witness, making the court process more complex and at times unintentionally blocking the view of other members of the court. It would be useful if a set of guidelines or practice directions be put together on the use of screens in the courtroom to ensure that it is able to achieve its intended purpose. D. Strengthening the bail regime. The amendments to strengthen the bail regime are welcome. This is especially in light of the recent case of Chu Eng Han, who attempted to flee Singapore while he was out on bail. I would like to ask the Ministry for Statistics on the frequency of bail granted in the past 5 years and the incidence of absconding over the same period. For those who had absconded, were they later apprehended, and what happened to these accused persons or convicted persons? I also note that under the bill, the court will now be allowed to grant bail in extradition cases if special circumstances apply. Under the current bail regime, bail cannot be granted at all for extradition cases. I would like to ask the Minister for the rationale behind this change and to seek clarification on what special circumstances are required for bail to be granted in such cases. E. Establishing a Criminal Procedure Rules Committee. I'm supportive of the establishment of the Criminal Procedure Rules Committee, which has conferred the power to prescribe court-related procedural rules to keep the court process nimble and up-to-date. Besides the 13 members identified in the bill, I would like to propose that the committee also regularly seeks inputs from the social science and technology experts to review the criminal procedure rules, identify ways to enhance the robustness and fairness of our criminal justice system. F. Regulating psychiatric expert evidence. In respect of having a court-administered panel of psychiatrists to ensure that evidence given by psychiatrists in court is competently arrived at and objective, I would like to ask the Minister what selection criteria will be applied to assess if a psychiatrist should be appointed to the panel. What safeguards are in place to ensure that the selection criteria do not inadvertently cause the composition of the panel to lack diversity of views which are within the limits of objective opinion? Are there plans to provide this panel of psychiatrists with training to enable them to better understand court processes and the role they play in adversarial proceedings, to enable them to be able to perform their role more competently? G. Expanding the community sentencing regime. The bill seeks to expand the eligibility for mandatory treatment orders to include offenders who commit certain prescribed offences carrying up to 7 years imprisonment from the current 3 years, and the maximum duration of the MTO sentences increased from 24 to 36 months. Amendments will also allow the court to order the offender to reside at the IMH for a specified duration of inpatient treatment as a condition of the MTO. I would like to ask the Minister to share statistics of the number of MTO sentences meted out since its introduction in 2010 and the type of offences to which the MTO has been applied. How many offenders have failed to comply with the conditions of their MTO sentences? How many offenders re-offend or cause harm to themselves or others during their MTO sentence due to their mental condition? I would also like to ask the Minister what community-based support does the offender receive during the course of the MTO, and what safeguards are put in place to ensure that the victims of these offenders are protected while the offender is allowed to remain in the community to seek treatment. For example, in the recent case where a woman was given a 2-year MTO for harassing her neighbor, the offender continued to harass her neighbors on a daily basis by verbally abusing them and throwing urine and rubbish at her neighbor's premises. It was reported that such harassment has gone on for years. In such cases, what can be done to ensure that the victims do not continue to be harassed by the offender as the offender seeks treatment? There is a need to provide a support system to ensure that the victims of these offenders are not overlooked as well. H. Deferred prosecution agreements. With regards to the introduction of deferred prosecution agreements, DPAs for short, Certainty and transparency must be ensured so that DPAs are not perceived as a way for corporations to game the system. In the United Kingdom, DPAs were introduced in 2014, and prior to that, the Serious Fraud Office and Crown Prosecution Service had published a code of practice for the use of DPAs. The code provides guidance on factors that the prosecutor may take into account when deciding whether to enter into a DPA. I would like to ask the Minister if a similar code will be published in Singapore. Under the bill, a DPA only comes into force when the High Court approves the DPA by making the relevant declaration. Upon the High Court making a relevant declaration, the public prosecutor must give public notice of the following. A, the DPA to which the relevant declaration relates. B, the relevant declaration. C, the reasons given by the High Court for its decision to make the relevant declaration, if any. Will the Minister consider making public the reasons given by the High Court in cases where the High Court does not make a relevant declaration? This will help to ensure consistent and transparent application of the DPA tool. This will also afford guidance on what cases are best suited for DPA and to provide corporations with more certainty in the management of their affairs. Mr. Speaker, I support the Evidence Amendment Bill. Child abuse and sexual offences are particularly traumatic offences, and victims are often afraid to come forward to report the offences due to a variety of reasons, ranging from being unable to make sense of what has happened to them, fear of the perpetrator, fear of judgment, and being subject to further humiliation and shame, fear that they will be blamed for their predicament, fear that they will not be believed, and the fear of having to recount and relive the experience repeatedly in the course of investigation and in the adjudication process. In adversarial proceedings, we can and must ensure that the victim of the offence is, as far as possible, protected from being re-victimized in the cross-examination process. The Ministry of Law has shared that the amendment to the Act seeks to restrict the defence from asking complainants questions or adduce evidence concerning their sexual history or activities, including their appearance or behaviour, other than those to which the charge related, without the leave of court. Such leave will only be granted if it would be in the interest of justice to allow the questions to be asked or the evidence to be adduced. I'm supportive of this move and would like to suggest some ways in which the scope of the amendment could be expanded on. Offences listed in the first schedule. First, the bill defines child abuse offence and sexual offence to mean any offence specified in the first schedule. In addition to the sections of the Children and Young Persons Act, Penal Code, and the Women's Charter listed in the first schedule, should Section 366 and Section 367 of Penal Code be included in the first schedule as well, given that these sections also deal with offences of a sexual nature. Besides child abuse and sexual offences, should certain criminal intimidation offences under Section 506 of the Penal Code or harassment offences under the Protection from Harassment Act also be treated in the same manner? In particular, where the criminal intimidation imputes unchastity to a woman or where harassment is sexual in nature. Could the presiding judge be given flexibility to decide to apply similar restrictions on cross-examination to those cases, even though they are not offences listed in the first schedule? Second, a set of practice directions or guidelines should be formulated to set out the approach prosecutors and defence counsel should take in handling child abuse and sexual offences. The guidelines will serve as a guide to help prosecutors and defence counsel put the amendment into practice without diminishing the right of accused to a fair trial. I understand that the Law Society is working on a set of guidelines of best practices for examination of children and victims of sexual offences and is aiming to issue the guidelines this year. In particular, I hope this set of guidelines will instruct defence counsel to refrain from making baseless submissions that disparage the character, integrity, or morality of the victim or premise their case theory on unsubstantiated myths and stereotypes to attempt to shift the blame to the victim. The Crown Prosecution Service, the principal prosecuting agency for conducting criminal prosecutions in England and Wales, has developed a set of guidelines on prosecuting cases of child sexual abuse and have identified a list of myths and stereotypes which should be challenged in court. These myths and stereotypes have been relied on by some defence counsel in representing accused persons in sexual offences before the Singapore courts. In defending his client accused of outrage of modesty, defence counsel in public prosecutor and Shi Jia Tong asked the complainant to stand up in court to assess her attractiveness and suggested to the court that he would have to know the complainant's breast size and whether she had been wearing low-cut attire on the day of the incident. The judge found that the defence counsel's line of questioning was indecent, scandalous, and intended to insult or annoy the victim. Not only were the questions offensive, I find it regrettable that the defense's case was premised on misogynistic stereotypes that the complainant's looks and dressing had, in some manner, induced the accused to outreach her modesty. This is an example of the type of myths and stereotypes which should not be perpetuated. In the case of Public Prosecutor MBLV, the defense counsel sought to rely on the complainant's ability to keep her composure at the time of interviews by the medical assessors and the complainant's good performance in school to indicate her lack of credibility as regards the occurrence of the alleged sexual abuse by her father. In Ng Jin Sian and Public Prosecutor, the High Court found that it was wholly unnecessary for defense counsel to specifically highlight that the victim was older, was sexually experienced, or that she was calm when she was examined by the doctor. More recently, in defending the accused who was charged with the rape of his biological mother, defense counsel made the argument that the complainant could have shut the gates by crossing her legs. The prosecutor submitted that this line of argument was premised on the antediluvian notion that a woman could resist a rapist if she really wanted to, and there was no room for such statements in the 21st century, both in the court and outside of it. While the prosecutors and judges had intervened in the aforementioned cases, the complainants had already been unduly subjected to unnecessary lines of questioning and assertions while being put on the stand. The set of guidelines should draw in references from these cases and set up best practices for defense counsel to adopt in formulating their case theory, to refrain from subjecting the victims to such unnecessary lines of questioning and assertions where such assertions do not mitigate or justify the accused's conduct or diminish the complainant's credibility. In respect of cross-examining child witnesses, the Law Society has come up with some draft guidelines on the approach that defense counsel should take when doing so. Some of these guidelines include adjusting the pace of questioning to the child's needs, making sure that the child understands the question posed, and ensuring that the defense counsel's tone of voice and body language are neutral. Besides these guidelines, the set of guidelines should also include best practices on how defense counsel should shape their cross-examination strategy in respect of child witnesses or witnesses of lower intellectual abilities, bearing in mind the general rule of practice which has been affirmed by the Court of Appeal in BMD and Public Prosecutor, that the evidence of such a witness is generally not taken at face value, as such witnesses may find it difficult to distinguish between reality and fantasy and between results of observation and results of imagination. Defense counsel should be sensitive to this general rule of practice and the particular circumstances of the witness and calibrate their cross-examination questions accordingly so that they do not inadvertently badger the witness and subject the witness to undue stress in addressing these inconsistencies. The guidelines should also include best practices on how the defense counsel should put their case to victims in child abuse and sexual offenses. It should be explained to the victims that in the course of cross-examination, defense counsel will put their case to them, and the questions posed may be upsetting to them as they seek to make out the elements of the accuser's case. On the defense counsel's part, care should be taken to formulate questions to suit the witness's level of understanding, such as through the use of short and simple questions, given that the language used conventionally by counsel in putting their cases tend to be complex and certain classes of vulnerable witnesses may be highly susceptible to suggestion. The aim of the defense counsel should be to elicit the most accurate evidence that the vulnerable witness is able to give, rather than to confuse or confound the witness to give an impression of a lack of credibility. I support the bill.